I think that there are plenty of attorneys in this valley that are perfectly great that would do a good job for far less. I think.
Well, I'm sure you're focusing on the law, not making a comment about the skills of the counsel, right? Okay, y'all want to get started?
Yes, Your Honor.
Gene's here. Okay, let's go on, please. Pages 8 through 25, Hunwardsen versus Infinity Lifestyles. Case 831543, counsels for plaintiff, please.
Your Honor, Will Kemp, Teddy Parker, and Eric Pepperman, plaintiffs.
Good morning, Your Honor. Joel Odou and Dane Smith from Woodsmith, Henning & Berman on behalf of Real Water. In addition, online, I see our co-counsel Eric Freeman, and I also see Robert Eisenberg, who is monitoring.
Okay. Sounds good. Okay. Folks, as you know, we have a plethora of motions on for today. So let me see if there's any order, any agreement, et cetera, that you'd like to do with regards to any of these motions. If not,
Your Honor, we've conferred, and we would like to be brief as possible today and possibly submit some of these and possibly just answer the court's questions. Looking ahead and speculating as to what the court may have the most questions on, and I'm just taking a guess, it could be the motion to tax costs. We could start there and answer the court's questions.
well, realistically, I was going to start with the other ones because I had inclinations on them.
That's fine too.
Because realistically, right?
It makes logical sense to start with the other ones. I agree.
Yeah, because otherwise it'd be, is there any quote foregone conclusions? Although you've seen, okay. So let's, counsel for plaintiffs, is that agreeable to you all?
Yes, Your Honor.
Okay, so I was going to, since you phrased, you have the renewed motion for judgment as a matter of law, or in the alternative, motion for new trial pursuant to NRCP 59 as to punitive damages verdict. And that is document 1297 with appendices 1296, 1320, appendices 1321, reply 1323. So, courts, yes? Do you need to slow down?
No.
Got to 1297? There you go. Okay. So, court's inclination is as follows. Realistically, the court's inclination is that it should deny the renewed motion judgment as a matter of law and the alternative motion for a new trial pursuant to NRCP 59 as the punitive damages verdict. Realistically, the court reviewing everything, taking additional looks at it, more than one, is the court does see, and I'm really citing page 7 of the opposition, which cites to part of what the court's analysis was at the time of the initial motion, is that this case does fit within the conscious, that the court did establish there was a conscious disregard consistent with Countrywide. It did say that, the court did say, and it was analyzed at the time, that the punitive damages was based on the 4 different prongs concerning Real Water's conduct relating to quality assurance, product complaints and investigations, testing, the lack of recall when Real Water had actual knowledge of the people that were suffering liver failure from the water. Each of those were 4 different prongs that were presented to this court as to a basis for punitive damages. They each were supported by substantial evidence of malice, oppression, and conscious disregard. There was the evidentiary support, not only Dr. Hutt, but other documentation. And some of the highlights of that is, remember, there was a big long discussion with regards to who actually was the QA person, whether it was the person who had no idea that he was the QA person, whether it was Patty Converse, the receptionist, and whether or not it was the third person, kind of like non-existent. So people do the fill in, I mean, and walking through each of the issues. So the court really, in its inclination, does find that for all the reasons previously presented, there was the clear and convincing evidence of the conscious disregard. The court is appreciative of the arguments raised that, in essence, it's a small company that kind of didn't know, or that Mr. Marlowe tested certain things kind of on itself. But realistically, the court doesn't find, and didn't at the time, find that that was a great argument, but it really just wasn't shown out in the evidence. The evidence did support the punitive damages going to the jury. The court doesn't see the prongs. We already walked through all the prongs 59, I can. But the court really doesn't see that the new motion for judgment is a matter of law under whichever 50 you want to go to, right? Got a couple of 50s in there, has been met for the different standards met. That's just a court's inclination. I give you a couple of examples highlighting, and I can walk through all the details with regards to the evidence if you want me to, but they're pretty much articulated in the opposition. Counsel for movement, it's your motion. Go ahead, please.
Thank you, Honor. Joel Odou for Real Water. I'll be brief. I appreciate the court's comments. Get up to a microphone so hopefully I can be heard and not get myself in trouble already. Your Honor, we hear what the court's saying, and there's a couple of interesting observations that we would like to make about the punitive damages issue and about the court's ruling, or the court's not ruling, excuse me, the court's inclinations and the court's comments. In particular, and this kind of goes across both motions. It's kind of interesting, right? Because we have the standard for punitive damages of clear and convincing evidence. And that's the standard for punitive damages. And then we have this different standard for prior complaints, right? And we have the standard from the Beatty case in particular, which we're going to talk about a lot in all the motions. But the Beatty case talks about substantially similar prior complaints. We actually cited this in our brief, and I won't go to the site.
You did, top third of the page, right hand side, yeah.
But it's kind of an interesting tension, right? Because we have two standards. We have this clear and convincing evidence standard, which is a fairly high standard in civil litigation. And then we have this more loose, is it substantially similar to these prior complaints? And where the plaintiffs never tied the evidence together, and where the jury, in our view, drew an improper conclusion was right there. Because the jury would hear a complaint about a real water bottle in 2014 being at a Chevron gas station. That was the one that was Exhibit 55 and 56. It kept coming up during the trial. The jury would look at that complaint and go, aha, that means that water in 2014 had hydrazine in it. And Dr. Catherine Adams Hutt, I misstated her name in our pleadings. I apologize to her. It's Adams Hutt. It's a hyphen name. Okay. She was very adamant that this put real water on notice. In fact, that was kind of the cornerstone of her testimony. And it's interesting that the plaintiffs bring that up in their opposition because she is assuming, and did assume, that was hydrazine in the water in 2014. And that's what made the plaintiffs sick in 2020. And that really was an assumption. There was no evidence at trial that these complaints were for hydrazine. These complaints were for various things, gasoline-like smell, discoloration, things like that. And plaintiffs go, well, aha, we had Dr. Najim say that it could have a gasoline-like smell. It could smell like gasoline. It could have a discoloration. And then when the plaintiffs took the stand, none of them testified that the water they consumed had an odd smell, had an odd taste. No, there was no evidence of that. So they never tied it together. So I go back to the fact in the punitive damages arena, if you will, which is all we were dealing with because real water admitted causation and liability. So all we're dealing with this evidence is, does it come in for punitive damages? And we had argued in the other motion, and we would argue here, that this is where the jury, for lack of a better word, went off the rails. This is where the punitive damages verdict became excessive. We had moved for a new trial seeking to have the punitive damages verdict overturned or reduced. Mr. Parker, in his closing, gave a quote from Steve Jobs, people are crazy enough to think they can change the world. And he invited the jury to change the world and issue $100 million. They asked for $1 billion, didn't get it in this case.
You understand that it is pointed out in their opposition, right? That you all had retrials. I appreciate different number of plaintiffs, right?
Right.
But punitive damages, and I'm not saying, right, I want to look at this court's ruling, I'm not saying the other ones, but consistently all cases went for the jury for punitive damages.
So the court is saying, okay, I'm looking at your case and
Oh,
looking
no, I'm
at,
not looking because I didn't know those facts at the time and I didn't take them into account. Actually, as you recall, at the time this case happened, Ren
Right.
had not even happened. And I had no idea what was happening next door because guess what? I intentionally made sure I had no idea what was happening next door because I was having the very next case. So I had no idea, didn't know anything other than if you all enlightened me here in the courtroom in a public setting on the record. So, but I'm just trying to, when I was reading through it, and I understand why, and I need some excellent argument, but I was trying to walk through. If you were trying to contend that the issue was that Hutt couldn't say it's actually hydrazine, or that she shouldn't be saying that they were on notice that there was some problem and people were getting sick from that problem. So were you saying that she had to specifically identify it as hydrazine versus it being, I don't know, regular chlorine bleach? I'm not, what I mean, any other thing that could get people sick if they drank it.
no, we're saying that evidence should have never come in because no one, not even her, not Dr. Najim, no one can say what happened in 2014. That's what makes that evidence so prejudicial. Because we as Real Water have no way to respond to what happened in 2014, yet we're going to be punished for what happened in 2014. Because that's the ultimate effect, right? Because it's a series of dominoes. The first domino falls when that evidence comes in. And we had objected to that evidence, both in motions eliminate, all throughout the trial. And the court seems.
But there's a plethora of Supreme Court cases, right? That prior notice is important, whether you take slip and falls and I don't know,
Yes.
right? It's a whole plethora of slip and falls at casinos, right? Or mega resort properties. And there's also slip and falls in grocery stores
Yes.
and clothing stores. I mean, depends on which case I want to think about, right? Because location. So that's realistically in trying to evaluate both at the time and now, your argument is it that anything of prior notice should not come in if you stipulate to liability?
So
Because how would you ever get to conscious disregard? You know what I mean, if you don't have the ability to even bring in the noticing, because in essence, what kind of seemed to flow is if you were saying you agree to liability, that there never could be punitive damages because you never could bring in prior notice. I know that's not your argument, but I was trying to walk through kind of the distinguishing factors that you were trying to contend in that nuanced aspect. Go ahead, please.
Yes, Your Honor, as the court correctly points out, liability and causation were conceded. So the only reason for this evidence to come in is for punitive damages. That's the only reason. That's where we start. So then the question becomes, what's going to be the threshold evidentiary burden for this evidence to come in and not be prejudicial, be more probative than prejudicial. And when you get to that burden, all we had was argument. We had no evidence. We just had argument because it's 2014. The evidence is stale, for lack of a better word. We don't have people from 2014 at the Chevron gas station come in and say, here's the bottle, let's go get it tested. So we assume, and the jury assumed, that if there was a complaint in 2014 and it smells like gasoline or it has this gasoline-like chemical smell, it must be hydrazine. There is zero evidence that there was hydrazine in that water in 2014. But okay, for the sake of argument, if it's going to come in, what is the evidentiary standard? The court went with the Beatty standard, said if it's substantially similar, it comes in. And we think that's where there's a tension in the law, if you will, between the threshold of punitive damages. It's just an interesting threshold. I understand the distinction, right? Because the jury has to find by clear and convincing evidence. It's not the threshold standard for the complaints to come in. I understand that, but I think there's this tension because you have these complaints, which we're going to assume are complaints about hydrazine, and then the jury jumps to a conclusion that it's conscious disregard because they knew about it in 2014. Our people got sick in 2018, 2020. Therefore, it's conscious disregard. And that's our objection, Your Honor. I apologize. Maybe I took the long way around the barn to get there.
No, I appreciate it. But the reason why I'm asking these questions, because I want to, I'm listening to everything you're saying, but I'm hearing what you're saying, but then what would it be the alternative? I mean, is that it would have to be, walking through your argument, right?
Yes.
Let's make it clear, slippery substance, right,
Yes.
on the floor. I'm gonna go somewhere different, okay?
And we talked about this during trial, so perfect
I know
example.
you did. That's why I'm
And-
putting you on you.
And I appreciate that, Your Honor. And as you recall, we had a discussion about the difference between the two,
Yes.
right? Because if it's there's the ladder case, there's the slippery substance case.
Mhm.
All those things, a layperson can walk in, and if they perceive there's a danger there, they avoid it. But the reason it's important for notice is because the notice is the landowner knew or should have known there's a slippery substance on the floor. The landowner can see and do an inspection and find the slippery substance. Here, we have an unknown poison that was in the water in 2020, and we're saying Real Water knew or should have known in 2014 when they got a complaint, investigated the complaint, didn't find anything. They should have known they were not doing an adequate investigation, and therefore they exercised conscious disregard. That's the leap of faith that we asked the jury to make that we think was improper, and that's where it all stems from. And there were other arguments, but I think this is just the most interesting one.
If you had a full opportunity, because if so,
I have,
I'll
Your
go
Honor,
back to
and
plaintiffs.
we'll submit the rest of the arguments on the papers again. We appreciate the court's time, and this was just the most interesting one we wanted to re-raise.
Yeah, I'm not limiting you. If you wanted to.
We didn't feel limited either. But we all unfortunately have another trial that we're preparing for, and we just know how to have a good time. So
Okay,
thank you, Henry.
okay. Who's taking it?
That would be me, Your Honor. I'll be extremely brief. I
I hear those words every day.
had one comment written down, and Your Honor actually already made it. You don't have to know that it's hydrazine. It's notice of a problem. It's the notice of a potential problem. They don't have to know it's hydrazine. That's what they ignored. They ignored all the notice of potential problems, notice of people getting sick. They never investigated it. And it culminated in the failure to do a recall, which that alone is substantial evidence of punitive damages. I mean, they don't touch that in the motion, in the reply, in the argument. They had the vice president of sales begging the vice president of operations. You got liver failure. I know I have a family member who got liver failure. I have a friend who got liver failure. It's the water. You got to do a recall or more people are going to get liver failure. And what did they do? They knew the probable harmful consequences of inaction, and they chose deliberately not to act. They didn't do the recall. That alone ends this issue. Your Honor has seen this correctly from the first time we've argued it and every other time and the multiple times we've argued it. Your Honor's inclination is correct and we would submit on that.
Counsel, it's your motion. You get last word. Go ahead, please.
Thank you. Just really briefly. They can't do a recall if they don't know there's a problem. They don't know there's something wrong. They never did. The evidence was, the only evidence that came in was the evidence of Brent Jones, which was played for the jury. They had no idea there was something wrong with the water. His own son got sick and he still had no idea there was something wrong with the water. So this to say, oh, well, you should have done a recall because somebody complained about a bottle of water in a gas station in 2014. That didn't happen at trial. And there's no evidence of that. Exhibit 55 and 56 from the trial with the Chevron station, which it's absolute as to what happened. There was a complaint. They went out and investigated it. They didn't find anything. Dr. Hutt said that investigation wasn't thorough enough, wasn't proper enough, but that's not recklessness. That's not conscious disregard. That's at best negligence. So Dr. Adams Hutt, excuse me.
Yeah.
Her own testimony doesn't rise to the level of conscious disregard regarding these prior complaints. And again, that's the problem we see here.
But it's complaints in the plural. It's not just, right? It's right, because part of the argument is complaints going back to 2014.
We started with the 2000, you're absolutely correct, Your Honor. We started with the 2014. There were some complaints in 2017. There's some complaints in 2018. This court in particular was very careful about what complaints they let in, not to say any other court was not, but I recognize this court was very careful. We chose to start with those because those are kind of the first domino that falls. But you're right, there were other complaints. They were investigated. They, again, were not investigated to the standard that Dr. Adams Hutt believes they should have been, but it doesn't rise to the level of business.
Okay, well,
Thank you, Your Honor.
no, thank you. Hearing everything, listening to it again, you all know the standard under, well, first for your 50, right? It doesn't, hearing everything I'm hearing today doesn't change everything that was presented at the time. The court doesn't find a basis. I'm going to incorporate everything that the court previously ruled and incorporate, like I said, that specific ruling, because had each of those prongs, had multiple complaints. The court did go complaint by complaint, to see what the jury would actually hear, and then had to evaluate based on what they heard. Was there enough for it to go to the phase of punitive damages? The court finds that it did do it correctly back then and does do it correctly now. I'm not mixing the standard of a reconsideration. I'm taking into account with renewed motion under 50. And so I have to deny the renewed motion. Then you look under 59. 59 is new trial amendments of judgments. Court looks at that for the punitive damages. I don't see any. Here you've asked for subsections A, B, F, and G. I'm reading from page 13 of your motion. So I looked at each of those. A, I don't see any irregularity in the proceedings based on everything that's presented. There was no misconduct of the jury. I mean, you all had a jury that was taking notes, paying attention, asking some questions, being here diligently. They articulated different things. They spent a significant amount of time coming to each of their determinations. I don't see that F. The excessive damage appearing to be given under the influence of passion or prejudice. I am not taking the other verdicts into account, even though they were cited in the pleadings, because as this court noted, one hadn't happened yet, and the other one I didn't know about. Okay. I'm not saying it wasn't publicly that I just didn't specifically know about. So, but looking at the damages and the ratio and what's allowed under a punitive damages statute, like the 2.99 cited in other briefs, I don't see it's excessive. I don't see it's excessive for the extent and the breadth, and whether I look at it at an individual plaintiff by plaintiff, or if I look at it in the grouping of the group, right? All five of them, I don't see how it is excessive. So I don't see F, G, an error in law, which is really the one that's mostly focused on the error in law. The error in law, I see it meets the standards of it. You've got Nevada Supreme Court case law says what you need to look at in order to allow certain things in or not allow certain things in. Damages was an issue in this case. Notice of damages is an issue you need to let in accordance with the applicable law, using the court's discretion based on what was presented to this court to determine whether or not it should go to a jury. The court finds that there wasn't an error in law. And by the way, of course, you objected, so that's not an issue. I don't have any waiver aspects, but and so I don't see the basis for 59 being met. It is so ordered that the motion is denied. Like I said, excellent briefing. Excellent. Let me see. Thank you. A lot of reading. So now let's go to the next one. The next one is Finity Lifestyles DBA Real Waters Inc.'s motion for a new trial and the alternative motion to alter or amend the judgment. Remitter request to stay execution on judgment pursuant to NRCP 62.
Your Honor,
Here, there's in part.
I was just gonna note it's 10:30. I didn't know if you wanted to go into this one.
Well, thank you for that courtesy.
Yeah, whatever the court's pleasure.
Do you mind, see how nice everyone's being? Because I've got these couple of I've got 3 Rule 16s. So I'm sure if these wonderful counsel, if I let them stay at counsel table, whoever's here in court is more than willing to go up to the podium if they get to jump ahead of me doing all the rest of these motions. And I'm sure people online are going to be quick and considerate in light of counsel. So you all don't need to move. If you need to stretch your legs, feel free to do so. But yeah, I'll quickly take care of some of these Rule 16s to get them taken care of. Would have been quicker if I had people actually show up to the mandatory Rule 16 conferences. Okay, thank you. So I don't need to do appearances again. I'm the same counsel, same case. We're back to pages 8 through 25, Hunwardsen versus Affinity Lifestyles et al. We are heading towards that second motion. I will restate the motion I'm on just so you've got clarity. I think probably helpful because you guys got 4 of them. We are on Affinity Lifestyles, DBA Real Waters, motion for new trial, and the alternative motion to alter or amend judgment remitter, request for stay of execution judgment pursuant to NRCP 62. Opposition thereto. The first one was document 1,299. And with the appendices, the appendices is 1299. The document was 1298. The op is 1319 and the reply 1322. So, and there's a partial semi-agreement, at least on part of the stay aspects. The court also has a inclination. Do you all want the court's inclination? Or you want to just start arguing?
Yes, please.
Yes, Your Honor.
Okay, so. Part of it looks like it's agreed upon, and I just need a little bit of clarity on the agreed upon. So the court's inclination to adopt the agreed upon that plaintiffs don't oppose the offset for compensatory and punitive damages, although there is a disagreement on the offset. My inclination on that disagreement on the offset is that counsel for Real Water has the better merit to the argument, because this court does not have evidence that the other entities, let's take Hunwardsen was the only individual who was affected by terrible herpes. The other ones were not. Brody had her own different aspects, right? And you even had issues about whether or not Brody, well, you had lots of issues with regards to the facts. That's the way I'm going to phrase that, kind of just more cleanly and clearly, so nobody misinterprets what I'm going to say. When I look at each of those factual distinctions, this court has not been presented evidence, i.e., see all your argument in the last hearing, right? That to know whether or not for the parties that settled, whether or not they would or would not have gone to a punitive damages phase, because unlike Real Water, they weren't even stipulating to liability. So you would have had the liability hurdle, et cetera. So in light of that, the court's inclination is I need to hear a allocation that would be consistent with the available information to this court, rather than taking into account the way that it was suggested with regards to the punitive damage component. With regards to the concept about whether or not there was a excessive aspect without a substantive discussion, I really think here that merits. I don't think it's excessive with regards to see everything I said in the previous inclination and the court's ruling in the previous, but also when you look at the actual facts that were presented realistically in the case. The customer complaint issue, see analysis and argument in the last one, and applies under the partially different standard that you've done here, but once again, the underlying facts and evidence just apply it to the different actual rule. The court sees that the customer complaints were properly admitted. The court's going to hear a little bit more on what was stated as far as the analysis of what was said in closing argument. I just need a little bit more clarity on that, on whether it was, the Evians of the worlds and stuff like that, and the Coca-Colas, or it was something different. And then the brief stay for 120 days seems to be a point of agreement, but once again, raised in the reply about whether or not that is a practical. So it seems there's some kind of stay, and I need to hear a little bit more on the true timing of a stay that is needed, because once again, this court's not aware of all everything else that's going on right behind the scenes. I don't have some unintended consequences, so I need to have a little bit better understanding of what is a practical stay. That's as much of an inclination as I have on this. I can give you really more underlying details, but I thought you might want to argue some of your points. Go ahead, please.
Thank you, Honor. Joel Odou on behalf of the Real Water defendants. We appreciate the court's inclination on the offsets, and pretty much leave that one alone. I think the only other piece of that was that It's pretty clear that all those settlements were paid by insurance, and insurance doesn't pay for punitive damages in those instances. And so, again, we think the offsets should apply to the compensatory verdict. The other little piece of that I do want to touch upon is that there's this argument that the punitive damages ratio to compensatory damages ratio should be adopted by this court. And the reason why that doesn't work is because, as the court points out, there was no punitive damages awarded against the ORP meters in the Gallagher case. So they had argued in other cases that, hey, we're not even responsible for punitive damages, therefore their offset should only apply to compensatory. And the other piece that doesn't work is punitive damages are meant to punish a specific defendant for specific conduct.
Or deter future conduct as articulated throughout your briefing, sorry.
Yes. And
Remember the
so,
whole, that's, yeah.
so we don't have that evidence, as the court noted. So I'll leave that alone. Again, we've talked about exhibits, I guess it's 56 and 57 at length in the prior argument about, the chemical smell and the gasoline smell, and attempting to link that to hydrazine. And we've made our arguments that is speculation. It was speculative to begin with. It was speculative at trial, and it's now a verdict based on, in our view, speculative evidence that shouldn't have come in. The court's made its rulings. We appreciate the court's rulings, and there's really not a whole lot to add in that.
This court does need a little bit of point of clarification, because I would hate somebody sorry, since you mentioned punish and I had to clarify and or deter, right, which was, as you know, because you all did it, right, significant aspect of arguments in the briefs. Just because the court didn't address it in its inclination doesn't mean the court didn't evaluate it. The court does find that there's two purposes, right? Because the statute says, right,
Yes,
punish or deter, right? So the bankruptcy, realistically, I would have readopted. And readopting everything I said about the bankruptcy and the whole analysis and everything I walked through with you all at the time of trial with regards to the bankruptcy, and the deterring function is also pursuant to law. And so that supports the last motion. And I should have said and also for this motion. I just realize I'm not going through each and every argument in your briefs. If for someone thinks that I should be, because for inclusiveness that you're thinking the court's only ruling on one thing and left open other issues, please tell me now, because that's not my intention.
We believe the court has fully reviewed all of the arguments made, and is just pointing out certain arguments that warrant further discussions. We don't believe that the court has ignored any arguments that we've made.
I was going to say, because I'm more than glad to discuss whichever ones you want. You all told me you were trying to be brief. You're prepping for another trial, so I'm just trying to be as expedient as possible in highlighting what you seem to be highlights.
We raised those issues in the brief. We had a very long discussion at trial about punishment and deterrence and punitive damages with defunct, out of business, dead entities. We also discussed, punitive damages being awarded multiple times against the dead entity. That was a new issue for this case, but it wasn't in the prior case. But we had a punitive damages verdict in Gallagher punishing Real Water for the conduct that they then get punished and deterred in Hunwardsen. And so it's really, that's the novel issue here, only because this was the second trial. But we have had that discussion, Your Honor.
Right, but just like a recall case on a car, right? Different plaintiffs, different states, whatever, you still have. No, I'm not going to circle back to opioids. I know that's Mr. Parker's favorite thing for me to circle back to for examples, right? I either go opioids or I go to DOT litigation. However, DOT got settled, so it's really not going to make my example here. And opioid got mostly settled with some little tangential things, but that's why I just say, the ignition cases, they're all over the country. I mean, that's. So see court's analysis previously incorporating all of that. That's the reason why I walk through with you all step by step, is to be honest, to go before the jury, because realistically, the jury had to evaluate what was actual, to be honest, right? The jury actually had to have accurate information and to provide information that wasn't accurate. I mean, and when there was a stipulation between the trustee as to who it was going after, right? Do we then tell the jury, no, this is going against an insurance company? I'm sure that's not what anybody wanted. Well, maybe one side did, but I'm sure your side didn't. Yeah, I mean, it had to be honest, but okay, so I incorporated that. I stopped you. My apologies. Please go ahead.
No worries, Your
So
Honor.
what is your offset ratio that you're actually request? I mean, because I don't because each side's asking, saying somebody needs to do some math, but nobody's told me what the actual math is to analyze, right? I've got
Okay, sure.
concept, right?
If the court looks at exhibit B that was submitted in camera,
Right,
we
that's,
put the total requested offset amounts. We probably should have put that in red or highlighted that in our argument, but I'm trying to be respectful of the parties who wanted to keep those amounts confidential. But if the court looks at exhibit B, you'll see a number for Myles Hunwardsen, total requested offset, and
you
there's.
can say the numbers, you can tell me to refer this, that's fine.
So does the court have the unredacted exhibit B?
Yeah, give me one quick second.
It should be under tab 10 of the binder we sent.
Right, and it also it's also in these, let me go back. Okay. Okay, let me hear from them and then we'll circle back to you. In other words, did you have an opportunity to finish whatever else you
I
wanted to
did,
say?
Your Honor. Thank you.
Okay. Go ahead, counsel.
Sorry, Your Honor. Judge, this is probably more of a philosophical argument, the way the numbers work, to be honest about it. And the reason I'm being philosophical about it probably is because this issue is going up to the Supreme Court now in the Chiavani case. I just got done doing the reply brief last month. So the issue in Chiavani is going to be how much do you allocate to compensatory and how much do you allocate in punitive? That's the
And can I get a point of clarification here? Because here's, this court's understanding is I have not been provided the underlying settlement agreement. So this court has to, based on the way that this is presented to me, is that none of those agreements had some specific language with regards to this is treated for X percentage for potential punitive damages. So I am treating it based on what you all presented in your pleadings without that knowledge. So if there's something else that.
Right,
Okay.
that's the primary issue in
Okay.
Chiavani, whether you do a Scrivener's test, you review the settlement agreement, and look at whether the clause says this, that, or the other thing, or whether you do the exposure test, that was what I advocate was advanced in Jay Johnson. But in any event, I'm not here to argue this extensively. I would point out a couple things. We've agreed with the general proposition that they get an offset. We're conceding it's the same injury. So they get an offset. So the issue becomes, how do you apply the offset? Whether you apply it to compensatory or punitive, or you do a ratio. So what we've argued is a ratio. I understand the court's rejected that. I'm not gonna.
Well, it's an inclination, counsel. If you think,
Here's the problem I see coming, Your Honor. So you don't have the benefit of the figures. We have the benefit of the figures. Okay, so let's just assume for the sake of argument that the prior settlements were approximately $50 million. Let's just assume that for all 5 plaintiffs. All right, and then let's also assume that the vast majority of it went to Mr. Hunwardsen. So I see really the numbers are going to come out about the same, either under the allocation proposal or the other proposal, because if you allocate all of the Hunwardsen settlement to compensatory, which is what their position is, then you have leftover money. So basically the amount that Terrible Hurts paid is going to be over what the verdict is. Okay. So that's going to be leftover amount. So that has to, either you don't apply the credit at all because you deem it all a compensatory offset, or there's a leftover offset there. And you can't apply it to the other plaintiffs, obviously, because it's the Hunwardsen settlement. So let's just, so the Hunwardsen verdict, I think, was approximately 22 million. So let's just use that 50 million figure, for example. And again, this isn't the correct figure. I'm just going to report examples because I don't want to violate the confidentiality agreement, the settlement agreement. But you're going to have leftover money that was settled for Hunwardsen. And, like I already said, obviously you can't spread it to the other plaintiffs because those aren't their settlements. You can't reduce their judgment amounts by someone else's settlement. But under their approach, that's it. It's gone. You can't flip it over to the punitives, because to do that, you'd have to say that it's so I think my way, at least for Hunwardsen, comes out better for him. But, I'm not looking for what's better or what's not better. I'm looking for what's theoretically the correct way to do it. But I would just point out that there's going to be a problem. And, this is, you know, we can work the number with Mr. Odou, we can get the court, the appropriate numbers, but I just think there's going to be a potential problem because of that. And that's why I think our proposal to use the actual jury verdict and use that ratio and apply, let's say it's 50 million again. So we say 3-1, so 12.5 million would go to the compensatory and 37.5 would go to punitive. And the court asks itself, well, why does it matter? The only way it potentially matters down the line is in the insurance coverage litigation. That's where it's going to matter. And that's not the court's concern, but that's why we're arguing about it.
No, and I appreciate where you are, which caveat, and I know you all kind of imply this in your briefs. There's a lot of statements about who's going to end up paying. You all know this because you
Right.
just stated it. That's not before me.
No, it's not.
Okay, but
So in any event,
okay, so I'm looking at page 8 of the actual motion, right? Page
Okay.
8 of Affinity's Real Waters motion, first
Okay.
page of the P's and A's. It's got the actual box. It's got that nice box that has the comp, the prejudgment interest and the total award.
correct.
And then I'm comparing that, and I compared that to the exhibit 10.
Mhm.
Okay. So I'm hearing what you're saying, but when I walk,
Okay, so
purpose, right, but if your purpose of settlement, right, is to try and,
exhibit 10 is the one that was submitted under seal.
yes, 10's under
Okay.
seals. That's why I'm just
All right, go
referencing
ahead.
as exhibit 10.
Mhm.
So I do realize that you had, that means for one person, there is more of an offset than the actual verdict. But isn't that the risk in every, let's take two people's, I'll use car crashes because it's the easiest, most common example, right? Two people responsible for a car crash, right? One settles out early because they don't want to have it. And guess what? The jury comes back. I'll make my example really easy. Maybe it's a defense verdict, right?
Mhm.
And the other person's overpaid. By definition, the plaintiff has still gotten their money. It's just really the pocket by which they're getting money. And isn't that a risk that, I mean, you choose not to do all the fees and costs and going to trial and having the punitive damage? And I just don't have anything before me that says those parties would have moved forward to a punitive damage stage. And I'm not going to use an example. I know you all are quoting to me other cases where some did and some didn't. I'm not going there because that has nothing for this court's viewpoint. I just have to look to see, do I have any evidence that those parties would have, even if I go back and look at your complaint, right?
Mhm.
And to see what is alleged against certain parties, or I take the policy aspect and say, well, what happens if somebody settles out pre-complaint, or right before, instead of filing a motion to dismiss, settles out? Would there be absolutely any evidence that there would go to a punitive damage? It's just, it's so contrary to that settlement standard that I don't see.
Yeah, that's why I think J. Johns really hits it on the head because
Uh-huh.
it adopts a pure exposure test. Was the settling party exposed to this type of damages?
What evidence do I have here? No, I read all that.
You have a complaint.
That's, but the complaint by definition is, the case law, because you're involved in some of the case law that says I can't take, it's not a motion to dismiss. I can't take the allegations as true, right? I can't.
But I mean, look at where we're at in the case though. The settlement, and again, we're talking primarily the chairperson's money. They were in trial. The punitive claim was going to the jury. So it wasn't just an allegation in a complaint. It was an allegation in a complaint that I think they filed a motion for summary judgment on punitive. I might be mistaken about that.
They did.
But yeah, so that was denied. So we were going forward with a punitive case against him. So this is not a case where it was just a complaint, as was the J. Johns case. Remember,
Right.
the J. Johns case was just a complaint, and they teased exposure out of that. But in this case, I think.
But don't I have to leave it to sophisticated litigators that if they wanted that offset, that would have been part of something that was presented to this court as evidence that, and not to go into things that aren't before me. I'm intentionally trying not to, I'm not going into things that aren't
Right.
before me, but there may have been reasons, or there may not have been reasons that people wanted it characterized one way or
Sure.
another way.
Sure.
There may be a whole bunch of reasons that have nothing to do with this litigation. May have to do with certain governmental entities. None of that I can get near with the 50-foot pole. Don't get near with the 50-foot pole because I have no evidence or anything before me. So I do not, have not, and will not.
That's their argument in the Kiabani case. Their argument in the Kiabani case is we should look for magic language in the settlement agreement, and that's going to determine the offset determination. But then they say, well, we can't just rely on the magic language test because plaintiffs could be collusive. They could be throwing magic language in there. So we have to, as a safeguard, we have to have the exposure test. So it all goes back to exposure in the final analysis. And that's why I think J.E. Johns was exactly right.
But I'm hearing what you're saying, but that's why this court's trying to be very careful about, I have nothing. I'm not saying, I give examples of some things potentially could have, but I'm not saying that's an exhaustive list or what the court would need. I'm just saying I have nothing to show that is
Not
evident.
quite, Your Honor, because remember, offset is an equitable determination that you're doing in your equitable.
Right, but I have evidence to go to that equitable determination for offset.
Right, and so there's two purposes of an offset. One, you don't want the defendant to have a windfall. In other
Correct.
words, you don't want them getting a credit for an amount that they shouldn't get a credit for. And in the J. Johns case, that was the 2/3 of the amount that went to the statutory.
Right, but I don't have that issue here.
Okay, so that's part one. Part two is you don't want the plaintiffs to get a windfall either. You don't want them to get compensated twice for the same injury. So that's the theory here. But again, you're sitting in a court of equity and you are in a unique position because you have heard the case. Now, you didn't hear the whole case against Terrible Herbs, I will admit, but you have heard the case. Okay.
I made a lot of rulings.
You made a lot of rulings in the case. So what better person is there, out of the vast universe of people, unless you're going to require another trial to prove the offset? And no court's ever done that because that defeats the purposes of offsets. They're supposed to be not quick, but it's supposed to be an expeditious proceeding. So that's why I think when you really think about it and you really focus on all the issues, this exposure test that Justice Hardesty came up with in Lindbergh is really the way to go. And so again, I'm not
But I'm
jumping
hearing
up.
you, but see, I even looked at exposure. I mean, I really evaluated both things, and even from an exposure concept, the claims against, I have to look to this case, right? This case, it's not that everybody's in the same shoes, right? Somebody was making the stuff.
Right.
And you don't want me to circle back to all the customer complaints, right, from 2014. That wasn't the issue with regards to. Be careful on the case that's currently. I was gonna say, I'm deciding whether I should use an example or whether I should say the actual.
I think you should use Mr. Odou's example because he made a good point,
Mhm.
which is that when we tried the meter case, we didn't win the punitive damages claim.
Why not?
Against Milwaukee.
That was my illusion, but remember,
But it went to the jury. There was exposure there. So
And then it was nothing, yeah.
I don't know how he can say that there's not exposure that motivated Hannah to make the settlement they did, which she's trying to get the credit for.
that's next door.
No, that's these
Oh, no,
plaintiffs.
yeah.
This is the credit that they want to apply to these 5 plaintiffs, the money that Hannah paid. And the money that Terrible Herbs paid. So it's a different situation. So Hannah, he's got a good argument that there isn't a valid punitive exposure because.
Because Hannah, in another case, would not think that they get punitive.
Yeah, okay. And in this case, Terrible Herbs didn't go to the ultimate, we didn't have.
It wasn't in that case.
Yeah, right. So, I just don't think you can do it that way. I think you're better off with the bright line exposure test. And so the ratio we suggested in the Kiabani case was just a flat 3-to-1, which is modeled after the Nevada cap, which is negligence. This is product liability. I know that. But in this case, we actually have
2.99.
right. So we're pretty close to the 3-to-1. So that's why we propose that. But again, Your Honor, this is not a hill to die for. I'm sorry I'm taking this much time.
No, and I thought it through, but your allegations against it,
Terribles.
I know, I'm pausing because remember, you all have potential appeals in front of this court. This court's trying to be very careful in its wording that I'm not articulating something that can get misinterpreted. Although, of course, eloquent people that you are, you'll probably characterize however you want to characterize what I'm saying, but the allegations against Terrible, I'll say, were different. They didn't, quote, in your words, didn't put the rocket fuel in the water.
No, but they were involved in the 2014 complaints.
Well, there's a dispute, wasn't there, about whether that
Dispute about that.
whether that Chevron was actually owned by Terrible Herbst at the time. et
There was a
cetera.
dispute over that, yes, Your Honor.
Okay. Yeah, I was reading a lot for this. Okay, but I'm remembering a lot, but theirs was basically one person during some specific time frame as a seller that got it from a distributor for ordering different things. And when I looked at that to try and say that somehow the punishment and or deterrence factors that the jury came up with were the punitive damages for the entity that mixed the water, made the water, your words, put the rocket fuel in. I'm not using those words, but that's why I'm calling them your words, right? Put the hydrazine in it or allowed the hydrazine to remain in it, or however you want to phrase it, is different than what you're saying Terrible Herbst did, is that it let it flow through commerce and did not have, in your words, the safety protocols it should have had to address prior complaints. And then, of course, you have your pump sticker.
Right,
thingies,
and,
but-
you know, and the thrust of the argument against Terrible Herbst on the punitives was they didn't adopt a third-party audit procedure like Costco
Yeah.
did. So that was the thrust of the argument, which wasn't really fully laid out because what happened in the case.
Right, but analyzing that, then if you wanted me to do it across the board, I had to do it for Costco.
Right,
And then I had to do it for Costco, which you were arguing had all the things that was different than,
and they ignored it. So they had the NSF report and they ignored it.
hence the challenges when I was walking through
Right.
each and every one of these and the arguments of the information that this court had at the time of the resolution for each of these, what I had in order to see if it would go to punitive damages. Did I have enough? I had to look at each of these entities separately to see what information the court had in order to really get to your ratio argument for punitive damages. And I appreciate you focusing on Terrible Herbst because A, it's the bigger number, and B,
Money is here.
yeah, but this court, if I'm going to adopt that concept, I had to look at
Right.
each and every one of those and the difference in the arguments and what was addressed with each of those, and would have to say that each of them considered it where realistically this court couldn't. So forever whether that's worth, I'm just trying to explain where I went, but
True, but if you don't allocate anything to punitive damages, you ignore truism, which is that the punitive exposure is what's settling a lot of these cases. Okay, that you can't ignore that truism. That is why Terrible Herbst paid what they did. That is why some of these others are running for the hills.
but is that a policy decision that this court should be doing when it's looking at equity? What is the fair allocation to get into the minds of an insurance company? Because once again, remember what this court also doesn't know. This court also doesn't know if these are, and doesn't take into account, because no one's presented to me whether these companies actually have insurance companies. I understand the real world. But what's presented in the papers is the entity settled, right? This is
Right.
not like, sorry, I'll throw it to some CD cases, right? Where some of my CD cases where you have people out of business and we know it's the insurance company because it's actually articulated to the court, right? A motion for good faith, we have to sign because you don't have the person there, right? Excelsior, stuff like that. And I always mispronounce that word, but you all know what I'm talking about. So anyway, my ruling is my ruling. I'm just trying to explain it because I'm interested in what you're saying. I'm hearing what you're saying, but
remember, the policy decision has been made for us by J.E. Johns. You referred to the policy decision. They made the policy decision that we will allocate based on exposure. That's what they said. They didn't look at, remember, there was a settlement agreement in J.E. Johns. They didn't look at the settlement agreement for magic language. They made the policy decision that you're going to analyze the exposure.
right. Everything I'm saying is in that concept of the exposure. What
Right.
information does this court have for the exposure? I'm not expanding J. Johns. I'm not contradicting it. I'm saying in looking at that analysis, what does this court have to look at exposure and have to look at it because I'd have to do the exposure for each and every one of these the
Right.
same. I can't say, I'm gonna look at the exposure for one, but I'm not gonna look at the exposure for all. I have to look if it would apply to this case for all of them, because I don't just have one entity. I've got multiple entities that settled at multiple different timeframes. against different plaintiffs. Not all of them had all the same plaintiffs. Anyway, you don't need my further explanation. You can agree or disagree with my ruling.
No, Your Honor, I'm not arguing with your ruling. I'm just.
Yeah.
I'm
No,
just-
I understand. I actually find this interesting. I'm sorry.
Yes, just to make clear though, we're going to apply it all to the compensatory.
Yes,
Okay.
my court's ruling is it applies all to compensatory based on applicable case law and the facts of this case and what's been presented to this court in these pleadings.
Thank you, Your Honor.
Okay, not taking into account what's happened in other departments upstairs, down, no, actually, I believe downstairs or sideways.
Your Honor,
Okay.
there's one point that I want to raise.
Your math point, your interest point, is that what you're
Yes,
going to go to the
ma'am.
interest point?
Just very briefly.
I'm sorry, I didn't want to speak for you. We were going to raise the interest point, but go ahead,
Yeah.
whatever point you want to raise.
It's in the interest of full disclosure, so the court is aware of the issue. We understand the court's ruling. We appreciate the court's ruling. We think the court got it right. There was a small dialogue between plaintiff's counsel and the court about there being excess. We don't know that there's excess until the court rules on the motion for attorney's fees and the motion for costs. So in the hypothetical that we were talking about, there's on page 8, there is a total award for Myles Hunwardsen currently of just in excess of $24 million. That's not a final number until this court addresses the other motions. And an offset could apply to those other numbers. And that issue has not, I don't know that this court has ruled on that, but that's what I want to find out. So let's say, hypothetically, let's say the court.
Is the clarification that these offsets are just a compensatory, or is going to be the total award if there are?
Yes, that's what
if
I'm
there are
asking.
fees and costs done?
That's what I'm asking. Yes.
Okay, well, I'm going to give you all. We can do the stay tuned as I get to each of those motions. That was going to be notice I did not adopt kind of what Mr. Kemp was saying as far as just.
Yeah, I just think we have to
compensatory.
address it today. That's all.
Okay, well, the court's inclination is that it does go just to compensatory, realistically, not to the fees and costs, wherever that is going to go down the road, because realistically, unless the same analysis that I went to punitives, is that this court's not been presented any evidence that, right, from exposure, that the fees and costs exposure played into it, so it's good for the goose, good for the gander, my best legalese in the morning. That without that evidence, you can't get the benefit of what may be a fees and costs award for an offset if that has not been presented to the court, that that's part of the exposure that any of these entities did. And if we shall, without going too specific, I'll just go to one of Brody's settlement amounts, it would be hard pressed to say that that particular entity, shall we say, look at numbers that they took exposure into fees and costs, given where they were in the case and given that number. And that was, so there's the court's inclination on that. Feel free to argue. I thought you all were going to bring that up in the next motions, but
We will, Your Honor.
that's a court's inclination on that. It comes straight out of compensatories. It doesn't include punitives and it doesn't include fees and costs to the extent depending where the court ruling is going to be.
Thank you, Your Honor. May I have just one moment, Your Honor?
Yeah, of course. Did they ask me on prejudgment interest yet? Whether it comes
Thank you.
from prejudgment interest too?
So we've got to talk about those in the other
And
motion.
then you also have to bring up whether or not those offsets come up from prejudgment interest,
That's right, Your Honor.
right? Do you all have an agreement? I have a question of whether or not you had an agreement about whether or not the offset would include the prejudgment interest amount or not. Because the prejudgment interest is straight from the compensatory damages number, right?
Gave that up, right?
I thought, I'm not clear, that's why I'm asking.
Get that up.
Okay.
Okay.
Okay. So do you all want to break it?
We're gonna reach an agreement.
Yeah, right. I think we
have Okay. I can check that off my list of things to do. Okay. So. Oh, fees, costs, motions to read tax memorandums, fees, costs. So. I thought. Do you want to go to fees or costs?
Possibly cost, Your Honor. If that's all right with the court.
That's fine. Is cost work okay for you all? Do you want to go to
Whatever the
cost
court's
next?
inclination is, Your Honor.
I don't have any. The cost aspect is, well, do you want me to walk through the 68 analysis on costs, or are you just doing the straight 18 analysis on costs that you want the court to do?
Your Honor, I was prepared to submit this on a brief. I have a lot of notes on this motion. But when we looked at costs, we looked at not only 18.050, we looked at 18.005, 18.020, and 18.110. I don't know that we need, for the record, the court going through each of these for us. I think that the motion and reply kind of sets out our position, I think, fairly well. I don't know what, having reviewed the opposition, I thought the opposition was pretty painted with a real broad brush. You know, in my opinion, a lot of criticisms of actual how the numbers came to what they are. So unless the court has questions for me, I would, like I said, I'm comfortable submitting it on the brief.
Well, we have to walk through experts, folks. I mean, I do need to walk through the experts. I have my points to walk through really were experts, special master jams fees, warehouse facility rental fees, and professional services. Some of the other ones, I mean, seriously, the charge for a peremptory challenge, I'm taking that out. You don't get, you know what I mean? Who you pick it, they shouldn't be. If you all choose you want a different judge, you all choose you want a different judge. I don't see that that's an allowable cost to the other side. That's a choice. It's not a actual necessarily incurred cost, right? Well, you know, we do appreciate it because it goes to our judicial education, but I don't see that. But the other ones, the ones I had questions on, I just noted to you all. So I had that, but did you all want to address the 68 issue, or is everyone okay with that?
Your Honor, I'm fine with the court
Okay.
addressing it however the court would like to. I mean, in terms of the experts, generally, Your Honor, we put on every expert in this case that we actually retained. You painstakingly heard their testimonies. They had reports and rebuttal reports. They were all deposed. And we spent a lot of time and effort developing the case. And one thing I pointed this out in I think every case we tried. Our experts actually tried to figure out the mechanism of how hydrazine was introduced to this product and how it eventually caused acute liver failures. I would say even more than what was done by any defendant, including your warden.
Can I tell you the nature of the focus of the court's questions really is potentially a lot with you, Haas, is what work was actually done for this case that these costs are being attributed to versus work done in general and then versus specifically for this case. You know what I mean? So that's kind of part of the focus, particularly when you've got $125,000 per person, because you know what I mean, a lot of that is background that's really being utilized for a variety of cases. Is it? So and I appreciate your concept is, guess what, they may have to pay it anyway, but do they pay it multiple times or do they get some credit because it's case by case? Go ahead.
So, Your Honor, I can address those for you briefly. I think when you reference 125,000, you're looking at Real Water's motion.
Yeah.
I don't know that those numbers were accurate.
But do you have a different number? Can you point me to where you showed a different
Yes,
number to the court?
in
Go ahead.
our opposition under experts on starting on page 10, we have Mr. Ulas's fees in the amount of $97,825.
Realistically, it was about 100,000. You know what I mean?
Yeah. So I just want to make sure that that's clear in terms of what we're requesting. For these experts, all four of them, it's solely for their billings related to this case. nothing to do with other cases. And that's why with Dr. Najim, for example, his billings are so low. It's pretty much just his trial testimony because he incurred his billings for his report in the Gallagher case. He produced the same exact report in this case. He wasn't deposed again in this case, so there were no costs associated with this specific case. Mr. Uhas, he was solely retained for Myles Hunwardsen. He was not retained prior to this case. All his fees were incurred in this case. That's why his are
Vis-a-vis real water or vis-a-vis other issues that did not relate to real water, meaning
these,
other former defendants.
all of these experts were primarily either the plaintiff's damages or real water. So for example, Dr. Hudson, he, focused on the individual plaintiffs that applied completely to real water, their injuries, their future needs, their damages, their causation analysis, these plaintiffs only. Dr. Najim, same, he was solely the hydrazine guy.
He wasn't the issue. I read through it. I mean, it basically starts page 9 and 10 of
Correct.
your op, right?
And
But
Mr. Uhas, damages, vocational and life care planning for Myles Hunwardsen only. That applies 100% to real water. And Dr. Hutt, she had opinions primarily related to real water's, quality assurance, quality control issues, general food and beverage safety expert. She did, testify as to other defendants and at the time of her, I don't know if she even did a supplemental report actually, but I think her first report included terrible herps, but in any event,
it was subject to motion. Don't you
inextricably
remember it was subject to
intertwined.
motion practice, motions eliminating stuff by terrible.
correct. I mean, they challenged her testimony, but her testimony was the same and it applied 100% to real water, regardless of whether there's another defendant in there challenging it.
Wormson get a lot of life care planners, right? And a lot of high-level life care planners. Never even close to this number. And I can go back to where you showed me like the breakdown of hourly rates and stuff, but there's just, I mean, he's not like he's. Remember the jobs he's had, remember the jobs he's eligible for, the type of stuff he's been doing. Right? I mean, other than the concept that he'd be shortened on that type of job because it's labor intensive. It's just real challenging to see what is there for that one.
Well, Your Honor, I would point out that Mr. Uhas's opinions were the sole source of over $1 million in damages for Mr. Hunwardsen. After his testimony at trial, we ended up stipulating to damages with real water at $900,000. They had their own life care planner. That was a very contested issue. It was a lot of money. And Mr. Uhas is from South Carolina. He traveled here. He evaluated Mr. Hunwardsen's home. He
Remember
met with
Fraser
him.
versus Drake, right? I have to look to see if similar experts in the area, what would they charge? What's the reasonableness? That whole lovely analysis, right? All those prongs.
Yes, Your Honor. So, and I understand that it was plaintiff's choice to hire an expert in South Carolina. So if there are certain amounts related to travel and that sort of thing that weren't reducing the cost award related to Mr. Uhas, I'm not going to argue with the court over that. I just, want to.
I don't argue with the court over anything. I just listen and make well-reasoned rules.
We think that the full amount requested for Mr. Uhas, which is just under the 90 or around 97,000 is
97,825.96.
was reasonable and necessary. And it was necessary to the award of a significant amount of damages that ended up not being contested after Mr. Uhas's testimony.
Okay. Counsel for real water, would you like
Yes,
to be
thank
heard?
you.
You can appreciate I'm not going with statutory minimum. That's
Your Honor, I'm just going to address the expert issue. I, like plaintiffs, agree that the other issues have been fully briefed and certainly can answer the court's questions. But I think there were certain categories that fall outside of the statutory awards, so to speak. Things like the, synced videos and things like that. We haven't talked about those things. And we do want to point out to the court that, hey, the statute doesn't provide for them. They can't recover from them. They don't like that they've got a remedy with the legislature. This is a pure statutory exercise as to what's recoverable in a bill of costs post-trial. We can go through those line by line, but I don't think that's necessary. I do want to address the expert issue though with Mr. Uhas in particular, but and I would disagree with the characterization that we agreed with his damages because they were so good. We agree with their damages for strategic reasons at trial, and those are our reasons. It's not that his testimony was so amazing for $100,000 that we thought, oh yeah, he's the guy for us. We didn't hire him. The court asked very pointed questions about, do those expert fees go to other parties as well, which is basically what the test is and what the requirements are to fees and costs. And if the court remembers and looking at it at tab 10, you can see that other parties settled the claims of Myles Hunwardsen for various amounts. And they settled those claims because of their exposures, according to plaintiffs. And part of that exposure was going to be Mr. Uhas's reports and fees. So we know that one of the many things that went into the soup, if you will, that those parties created in deciding to settle their claims, not only was the things that happened at trial, but was the expert reports for Mr. Hunwardsen. And the same would be true of Brody and Schaefer. I do appreciate that the costs for Dr. Najam was about $6,000, and that is a lot less because liability was conceded in October of 2023 and was never going to be an issue here. Our principal testified there shouldn't be hydrazine in the water, but again, it's plaintiff's burden to show these different fees and costs beyond the statutory amounts. And separate and apart from this motion, we have the motion for attorney's fees where they're seeking Rule 68, I think, the fees and costs of Greg Dooley and Michael Rich. And I'm not going to address those arguments here. My colleagues going to address them when we get to the attorney's fees motion. But I think it's worth noting because it goes to the fact that, they keep saying, well, all these experts were to real water. No, these experts were for their entire case. There were multiple defendants. There were multiple claims in the case. Dr. Hutt in particular, initially her reports were targeted at other people. Those people ended up settling out. And so she testified at trial. By the time she testified at trial, everybody else was out of the case. But her report addresses UNFW, it addresses Costco, addresses NSF. I mean, her report is not just, here are my opinions on real water. It's much broader than that. And so for that reason, if the court's inclined to award a fee for Dr. Adams Hutt, we would just request it be reduced pro rata by the other defendants. And the same is true of the majority of the other defendants. Again, I'm not going to quibble with Dr. Najam. I think his fee is more proportionate to the case, but Mr. Uhas's fee is outrageous. And Dr. Hudson, again, his fee is really for the entire case. He's going to render opinions whether real water is here or not. If this case had gone to trial with just Terrible Herbs or just the meter defendants or just Costco, those opinions would still stand. So I think the court has rightly recognized there's got to be some adjustment made.
Okay. So are you still contesting? Okay, I'm hearing what you're saying about special master fees.
Special master fees, Your Honor.
Is that for this, that was unclear about whether or not that amount for special master fees was allocated to this specific case. I am very appreciative that there was some specific work needed to be done on this case because of certain things you all wanted, but
Not a big percentage. Again, there are, I think 18 current cases coordinated by the special master. And, plaintiffs have generously allowed the other cases that are coordinated with him to be just billed under one case. And, I appreciate that makes Mr. Hale's job easier because we do have other plaintiff law firms like we did in the recent trial. But clearly, the amount of special master work for this case could have been broken out and could have been discrete about, hey, here was this motion as to, I'll give the court an example, a dispute over, the life care plan. So here's a motion that was in front of Floyd Hale for just that. But, general status checks with Floyd Hale, general hearings with Floyd Hale, they concern all 18 cases now. It was probably 16 when this case went to trial. I don't have that in front of me though. So yeah, I do think there should be an accommodation made.
But is it, where I was trying to go back is, okay, they reference, it's 832 to whatever, it's referenced in their appendices, right?
Right.
Which ones? So it was unclear whether you all are in agreement or not in agreement as to whether or not this is an allocation of special master fees to this case, either by dividing it by 18, right, or whatever the number is. Because remember, it's not all these counsel. These counsel don't have all the cases. So special master was coordinated, through Judge Alf, but as the cases got filed, so certain things had already been down the road for a while. So do you want me to ask counsel for plaintiff who's standing up to get a clarity on what?
Yeah, I mean, it's
actually
not a gigantic number, but we would appreciate some clarity on that because it's just not clear that it's just the 24,000 is for this case.
Counsel, would you like to address it since you're standing up? I'll go back to
yes.
Mr. Odou.
Yes, Your Honor, and I do understand that this was a little confusing. I believe in the memorandum of costs, we initially requested 100% of the special master fees.
Right, your line 20 asks for the 24,954.78 with reference to APP 832 to 841, but those reference numbers weren't specific to this case.
I know what the mistake was. In our opposition on page 19, we correct it. Basically, we take the entirety of the special master jams fees that we had at the time through this case only, and then we divide it by 14 because our firm has 14 separate actions. So we took 1/14 of it. And so you get the number of 13,792. I think that number was off in the original memorandum of cost. So we acknowledge that and reduce it to 13,792, which we think fairly and accurately represents the pro rata share of the cost related to this case only.
But does that, where I was trying to go with that mathematical calculation, you did it from a temporal component, right? Did you do it from the case date, case file, it looked like, to date, case judgment? Correct?
I don't recall off the top of my head in terms of the date case filed. I think we took the number that we had in fees at the conclusion of this case and took that number was the 193,096 and divided it by the 14 separate actions that we filed.
But that would allocate for us. This has 5, right? Some of yours had 8. Some of them had different number of plaintiffs, had a lot more case specific. I understand it's some percentage. I mean, where I'm really inclined on this one is to head it back to you all to figure out a number. If not, I'm going to get a number because, and you're going to risk the fact that you might not get any because I don't have a breakdown. You're going to get some, I shouldn't say you're not going to get any. You're going to get something, right? Because I at least know certain things that came to this court. Because remember, not consolidation as you put in here, it's actually coordination, right? Coordinated for discovery only. And then this court did its own Just, you know what I mean? Remember, this court did a lot of those motions itself. They weren't too many reports and recs that came to this department for this case. While he's appreciative that certain things moving forward had a benefit to this case, and certain things were specific to this case, but is this one I should just have you all speak among yourselves and decide that you can come to an agreeable amount versus the court picking an amount?
Your Honor, while Mr. Pepperman was speaking, I had an opportunity to re-review our reply brief, and there's been a lot of moving parts. And I apologize, we did concede this in our reply brief, that if the court was going to award special master fees, then we are in agreement as to the
13.
the pro rata calculation that they did in their opposition, and that's on page 11 of our reply brief. I apologize, Your Honor.
No worries. And like I said, that's why I said some of these are moving targets, because I appreciate you all being conciliatory. That's why, okay. So yes, I am. I find it's appropriate. I find because here you all requested coordination. This was not court ordered coordination. You requested and wanted to have a special master. You all, by agreement of the parties, wanted to incur that cost. You all then agreed upon the method by which there would be generalized payment to said special master. So yes, the court would find by agreement of the parties here, special master costs would be appropriate. 13,792, the amount, and 61 cents, the amount of which agreed to by the parties based on the court's ruling that I am going to grant special master costs. Does that work for the parties? You want some more argument on that?
That works, Your Honor, for us.
Yes, Your Honor, thank you.
Okay. Warehouse facility rental. I have the same question on warehouse facility rental, because when I look at the warehouse facility rental, right? Is you change that one again as well in your opposition on page 19 at line 23. Between your memorandum of costs and your opposition to their motion to retax, you went down from 34,000-ish down to 10,899. You see that on line 19?
That is correct. The 10,899 is the number we're seeking to recover based on the same pro rata formula that we did with the special master fees.
Okay, so then it appeared on page 11 of your reply, Counsel for Real Water, going right under special master fees. You understand why I'm asking these were the ones that are changing numbers that happen. It says real water maintainers are not awardable under, however, the court were to find these charges are taxable. Real Water believes the pro rata calculation to the 10,899.89 needs to be further apportioned, not based on the number of cases, but on other defendants in said cases. So here it seems that you wanted to really, well, your ceiling's $10,899.89. How much time do you want to spend in front of me arguing about that versus seeing if you can come to an agreement on a further apportionment of that amount?
I think we can come to an agreement.
That's fine. Yes, Your Honor.
So shall I leave a blank line on that one when you submit the cost order to the court? Or if you want me to rule on it, we'll walk through it all. You understand I'm gonna have to ask you
Take a
about.
moment to talk to Mr. Pepperman.
Yeah, sure. Because I think you're about to tell me a number.
Yeah.
Good, go for it.
Your Honor, we reached an agreement that the 10,899.89 is a fine number. We don't need to argue that further.
Okay, whew, got that line taken care of. Okay. Professional services for holo discovery, and you all broke that down. Here I need a clarification point, because you've got the professional services as one category, and then you have trial support / exhibits as another category. Are those overlapping categories, or are those really intended to be the same category? You understand, one's your subpart 6, trial support exhibits, and the other is professional services, but you go to holo, it's just not really clear.
Yeah, I think the way that we tried to organize it is based on the categories under NRS 18005.
Right.
And so since both of these we find fall under the
17.
section 17, we included them together, which.
No, you did them separate. They're argued separately. Sorry, the trial support / exhibits is argued in one part, and professional services is argued in another part, even though the reference part to both of them is subpart 17, at least that's the way this court saw it with regards to looking at the memorandum, the motion, the opposition, the reply. If you have a different view, point me to it. Go ahead, please.
No, Your Honor. Conceptually, we believe that both of these are considered professional services that fall under the section 17 catch-all provision, but we combine the numbers. I think they can be broken through in the backup in the invoices that we have attached to the appendix, but we just included one number for both separate services, I should say.
Counsel, I think you and I are not saying the same thing. Go to page 3 of your memorandum of costs and disbursements. Page 3, between line 25 and 26. See column 19, exhibit 19, trial support and exhibits, $7,501.99. Then go to page 4 of your memoranda, column 22. You have professional services of $69,304.36. Your reference to both of those appear to be subpart 17, but at least in your memo of costs, and then articulated starting on page 11 of their motion, sorry, your opposition to their motion to retax. I could pull the document from their motion to retax. They're argued in subparagraphs 6 and 9 as being distinct with different analyses. See why I'm keeping you all here versus trying to do this on my own? Because there's questions, folks.
Yes, Your Honor, let me look at the appendix here.
Right, one's got appendix to 760 to 831, and the other has an appendices to 848 to 878. Your appendices references are different. You want me to know where I'm going to go from there as well? I'm going to then ask you, is there an overlap between your HOLO charges and your line 12 on photocopy, printing, and scans? Since a lot of your HOLO charges are printing and scans as referenced.
That one, I know the answer to that is no.
So those are internal ones with your machines versus HOLO machines?
Correct, Your Honor, yes.
I wasn't sure on that one. That's why I was breaking down to a two-part of it. Yeah.
Well, actually, I believe that to be the case, but I can confirm in the backup that that is true.
Your backup is different. 288 to 512 is your backup. Well, okay, instead of segueing into two different things, can we do your exhibits versus your professional services? Your 19 versus your exhibit 19 versus your exhibit 22, and how those are both? And if you want to tell me that you are going to come to an agreement on those amounts, and I should move on so you have a few minutes to do attorney's fees, I'm okay with that. You tell me what you, actually don't tell me. If you all have a request, feel free to tell me what your request is.
Your Honor, we don't believe those are recoverable, but if the court has an inclination that they are recoverable, we can probably come to an agreement.
I do have an, do you remember the last couple of years, the trial presentation, you know the case I'm talking about, right? With regards to the presentation and how the court found that, even though there was some pre-trial things that was done. Realistically, I think the Supreme Court has found that it is, if it meets within that criteria, which is why I'm asking the question of this distinction between quote, what's professional services. If it was just trial support and exhibits, they'd get it realistically. But the fact that they've asked for similar type stuff, it appears under professional services category with HOLO, and it's not clear whether it falls within the case or doesn't fall within the case is why I'm asking the question.
Gotcha. I think we can come to an agreement on that part of it. So to answer the question.
This was $69,000. I mean,
it's not an insignificant amount, but if it's recoverable, then,
do you all want to revisit that yourselves and agree upon line blank or put two proposals in your proposed order?
Yes, Your Honor, I think that would be.
Right. Does that make sense? Do you understand what I'm saying? Is that you submit the proposed order right on the cost is going to be either you've all agreed, which nicely you've done that a lot. Thank you. But if you haven't, then plaintiff says A and defendant says B, and then the court's gonna have to look to see. Does that meet you all's needs?
Yes, Your Honor.
Yes, Your Honor, thank you.
If you wanna keep going on it, I'll keep going on it, but it seems to me you all wanna check some stuff before you really wanna.
Well, we want to be efficient with the court's time and we want to get to the more meaty issues.
Okay.
But if there's
So,
anything else.
More meaty
that
is
costs-
attorney's fees, right? 68 and 17, right?
Yes, we know you.
Yeah, I will tell you, I have to relook at UHAS because. Like I said, that is. I don't see that number of any life care planner when we've had very, very. Large life care, with multiple options and multiple things with people, a whole bunch of different things. I have Fraser concerns about that one. So do you want the court to decide on UHAS on my Fraser concerns, or do you want a chance to speak with opposing counsel?
I think the court can decide that one.
I'm fine with that as well.
Okay, then that one's in my rule, okay. And I have to look at the expert fees then, okay. I'll relook at that because I have questions on that, so. Counselor Plaintiff, you're gonna double check also your paragraph, your 12, your photocopies, printing scans, as that compares with the other printing charges that may be in 19 and 22, right? And just work with opposing counsel on that.
Yes, Your Honor, looking at this, I believe the professional services are limited to the cost to maintain Polo, not for any particular copying expenses. I noticed in the trial exhibits section, there were exhibit costs from Polo in the backup. So I believe those actually copying services are separate from the professional services.
But isn't that what you and opposing counsel are gonna take a look at and just
Yes.
kind of see your agreement, right? Where I was going is then looking at your line 12, your photocopies and printing and scans under subpart 12. Can you also take a look at that when you're speaking with opposing counsel? Like I said, if you have a line that says, look, you're still sticking to that when you submit it, plaintiff proposes this and defendant proposes that, do it in your cost one, because it looks like you have overlap there as well. If you want to spend the time walking through, which you really intending, then we might have some challenges getting you through. Then I may have to either A, continue this, or have you come back before my 2 o'clock, which is realistically your firm on 2 o'clock in a different case.
No, Your Honor, Mr. Odou and I can meet and confer over this, and I'll look to confirm what's included.
Also,
We agree.
does that work for you? Bingo. Okay. So let's get to your 6817, your offer of judgment, right?
Yes, Your Honor.
Go ahead. How are we doing? By agreement of the parties, how are you all doing it? Since it's a motion for attorney's fees, I normally would let plaintiff go first and then you
Fine.
both, okay. Ms.
You
Parker,
already-
are you taking this one? Go
I
ahead.
am. The last one I thought I was taking until it went into the motion to retax. Your Honor, this one I think is pretty easy. I thought after reviewing the briefs and writing down a bunch of notes that what was most convincing to me were the offers of judgment made by the plaintiffs and how at the end of the case, Real Waters suggested numbers to the jury exceeded 4 out of 5 of those offers of judgment.
Mhm.
And so for now, for Real Water to come back later and oppose an award of attorney's fees, post offer of judgment, and post refusal to accept those offers of judgment, I think it should not be well taken, Your Honor. We, in addition to citing NRCP 68 and 17.117, cited all of the cases that we typically have the court consider, which is the Dillard Department Stores case, the Mendenhall case, and of course, the Albios case, Your Honor, which I'm sure the court is very familiar with.
Abios versus Verizon, it comes up in CD all the time. Go ahead.
Absolutely, Your Honor. And we also, for purposes of the 40%, we of course cited the shooting case, which the court is familiar with, the University of Nevada versus Tarkanian case. And the fact that Nevada rule of professional conduct recognizes contingency fees. Your Honor, in terms of the contingency fee amount, that being the 40%, we also cited to the O'Connell versus Wynn Las Vegas case, and the one that's cited by every, I think, plaintiff seeking 40% after prevailing and beating its offer of judgment is a Capriati case, Sean.
You love 2021. Go ahead, please.
Absolutely, Your Honor. So you're familiar with the cases, Your Honor. The backdrop you're also familiar with. This case was a hard-fought trial, a month long. We spent a ton of time, attorney time, preparing for this case. Your Honor remembers all both the pretrial motions, how much time you gave us to go over those. I believe we had 70 depositions, over 100, I think 21 pretrial motions. We had virtually a month worth of trial, Your Honor. And so I believe we've done everything to support an award of attorney's fees under the statutes, under the rule, and under the cases related thereto. We cited the Beatty factors, Your Honor, and we went through each one of those 4 factors. And of course, the 4th factor under Beatty, whether or not the fees sought by the offeror are reasonable and justifiable, those bring the court, of course, to the Brunzell factors, the 4 Brunzell factors. And we went through each of those, Your Honor. Based on my review of Real Water's opposition, Real Water seems to be using the bankruptcy as a sword and a shield, suggesting that the bankruptcy prevents an award of attorney's fees and costs. I've seen no case law to support that position, Your Honor. There's none cited that supports that position, Your Honor. The plaintiffs also seem to concede that we meet the majority of the Beatty factors, Your Honor. And in terms of the Brunzell factors, seem to suggest that they did not act in bad faith. Your Honor, I think that the point should be made, and I think Mr. Odou has made it in part for me. Their expert indicated that this was a problem caused by hydrazine created by Real Water. They had no real, once we got into the meat of this trial, and really just before the trial started, they admitted to the defect and causation, Your Honor, but we had to go through and put on all of those experts in our prosecution of the case against Real Water, also to support the punitive damage claim. You know, I don't believe that Real Water's opposition should be taken very seriously when you consider the bankruptcy arguments that are being made. The Real Water's insurance company decided to defend this case. They decided whether or not with Real Water to accept offers of judgments. It's not like Real Water came here and agreed to an amount and we did approve of. That's not what happened here. We were forced to go the distance from beginning to end, Your Honor, and the jury gave us an amounts in excess of our offers of judgments for all 5 of these plaintiffs, Your Honor. So with that said, unless the court has any questions, I believe we meet the factors under Brunzell and meet the factors under Beatty. We are certainly, our request is consistent with 868 and with NRS 17.117.
I do have 2 questions, if you don't mind. One of them is it's argued that the punitive damage component, right, puts your fee award, if granted, at around $53 million.
That is correct, Your Honor.
And they gave a lovely number of how many hours that would be at $500 an hour in their brief.
Yeah, Your Honor, I found that argument somewhat comical because I hear so often back and forth because I'm typically on the defense side of most of these cases as opposed to the plaintiff. I've heard that argument before, but it for some reason to me is nothing more than a distraction from what the rule provides. The rule says if you beat your offer of judgment, you get your fees and costs, and then it tells you the factors to look at. One of the factors is not, well, should you compare the hourly rate to each person, unless you're doing a lodestar analysis, which we're not doing that.
Can I stop for a second? You might have misunderstood what my question was.
Oh, sure.
Basically on page 7, right, of their opposition, I can read the sentence, says plaintiffs provide no case law to support the excessive amount under NRCB 68, which is approaching double the compensatory damage award in this case. To put it another way, if counsel billed at $500 an hour, $53 million would cover 106,000 hours per annum, the equivalent to approximately 12 years of working 24/7. What they're basically appeared to be saying is when I'm looking at, obviously contingent fees are allowed, right? So in essence, what they're saying is when I have to look at the reasonableness, right, is that if you were doing an hourly rate, right, Visa versus Shooty, you can look at any top, right, any of the various opportunities for awards. Here, while contingency is allowed, the court can look at contingency. Should I give the percentage of that contingency? Because if I were to compare it to, I base it more succinctly, but if I were to compare it to an hourly rate, and they don't seem to be contesting the 500, right? But there's, an hourly rate of 500, that it means you'd have to work for 12 years, 24/7 to get a similar rate. And so therefore, that would not be, quote, a reasonable rate, because if you are hourly attorneys, there's no way you could get it even at $500 an hour, because it's not a 12-year case. Did you want to address that kind of concept?
I think this comes under Capriati. Mr. Kemp was whispering in my ear, but
Sure.
it's on, if you were to look at our motion, page 23,
Sure.
in the Capriati case, the Supreme Court affirmed a $2.3 million in attorney's fees on a $5.9 million award. Your Honor, there was no analysis or the Supreme Court didn't buy this analysis of how many hours it took. It simply agreed that a contingency is allowed under our rules of professional conduct. A contingency agreement was agreed to by the lawyer and the client in that case. They beat their offer of judgment, which the offer of judgment in that case was $4 million, and the jury gave them 5.9. Our offer of judgment, if you were to total those all up, would be a fraction of what we ultimately got in this case, Your Honor. Your Honor, the other thing I would point out, Mr. Kemp hasn't made $500 an hour for 20 years ago. His numbers, his value is a lot more than $500 an hour. And Your Honor, I also, because we pointed this out in our reply brief, the chilling effect it would have on plaintiffs or claimants being able to get quality lawyers if they were relegated to an hourly rate on cases like this. So, Your Honor, I think the Supreme Court's already answered that question. It appears to me, when you consider the real water opposition, that they although I believe they did cite Capriati in their opposition, they recognize that this hourly rate is not an analysis that should or needs to be performed under the Supreme Court Capriati decision.
Appreciate it. Go ahead, counsel.
Mr. Smith will do the
Oh,
presentation
sure.
for us.
Thank
Go
you,
ahead,
Your
Mr.
Honor.
Smith.
I find it quite comical that plaintiff's counsel said there might be a chilling effect if this court does not award them a $53 million attorney's fees awards in this case. I think that there are plenty of attorneys in this valley that are perfectly great that would do a good job for far less. Also want to talk about Capriati real quick. I think
So I'm sure you're focusing on the law, not making a comment about the skills of the counsel, right?
correct. Your Honor.
Okay,
Yes, Your
that's the
Honor.
way the court needs to take it.
Yes, I meant no disrespect to opposing counsel. And I think the court is directly on point regarding the reasonableness of the award.
You realize I was quoting your brief. I just was asking them a question, quoting your brief. I'm not taking a position. Go ahead, please.
Absolutely. I think that's where the focus should be at the very least. Capriati stands for the proposition that the court is entitled, if it finds it is reasonable, to award contingency fees. But certainly even the Capriati court itself noted that the Beatty factors and the Brunzell factors still need to be satisfied. I'd like to next turn to Real Water's precarious position in this litigation and ultimately why it was reasonable for them to reject these offers at the times they were made. During this case, as the court is aware, Real Water was in active bankruptcy and had limited insurance funds for a great amount of claimants, including the plaintiffs in this case. Even if Real Water wanted to accept the offers in this case, it practically could not. This was a very unique situation where a company was in the middle of active litigation while it was also bankrupt, it did not have any power to make any settlements. Plaintiffs were very aware of the issues that Real Water faced when assessing these offers of judgment. I believe we attached to our opposition in Exhibit C letters that we had sent to plaintiffs' counsel regarding the issues with their offers of judgment, specifically the limited policy and the excess of 100 claimants.
Counsel, can I stop you real quick second?
Yes,
I just wasn't, it wasn't clear from your argument whether or not you were contending that precluded it under NR 17 or NR CP 68, or just to evaluate it for the reasonableness. Can you just clarify that point?
Yeah, if I'm understanding the court correctly,
I can rephrase. What I mean is, when you attach the letters, when you're saying that that means that anytime somebody's in bankruptcy, it's automatically reasonable to reject offers of judgment? Or were you just saying that this is just a factor the court should look at, that you put them on notice? That was my point of clarification. You don't mind? Thanks.
Yeah, we did not mean to make any per se rule. We meant for those letters to go towards the reasonableness.
Thank you. Appreciate it.
And I think that, you know, a lot of our arguments we bring up in the brief were communicated to plaintiffs' counsel at that time. We weren't hiding the ball. It was a nuanced issue. And certainly Real Water was of the position that it could not accept these offers due to a variety of constraints. I'd next like to turn to Real Water's defenses real quick. And under the Beatty factors, it's relevant to the extent that they were litigated in good faith. And I think that the best evidence that Real Water did litigate in good faith is what it brought before the jury. Before trial, Real Water did concede liability. And as Mr. Odou said, its principal had admitted that hydrazine should not have been in the water, period. At voir dire, Real Water also told the jury basically that this was a damages case. And admitting the liability and really shaving down the issues for the trial shows that Real Water was actively assessing the information and the evidence and only wished to remain or litigate issues that it saw as viable.
Sure. I gotta stop you again. I'm sorry, Mr. Odou, I have to jump in here. Do you all remember? I'm not sure if you were at the hearing. Remember, this was an issue about whether they were conceding liability in this case, because remember, there was a question about it at a prior hearing. I'm not trying to put you on the spot, Mr. Odou, but and it wasn't you, it was other counsel, right? Because there was a statement made earlier on that this was going to be admitted liability, and then other counsel came in and said that had not yet been decided. I'm paraphrasing, it may not have been the exact words. Now, ultimately it was done, but is which time period? I was trying to reconcile. Well, first off, do you disagree that happened?
Your Honor, Agility for Real Water. Yes, I understand what the court's referring to. There was some motions at pretrial hearings. What Mr. Smith was referring to was voir dire, which is after the pretrial motions and hearings. And the issue really was one of medical causation. There was an issue of medical causation that was considered to be disputed and eventually conceded in this case.
Okay, what I was trying to do is I was trying to put the layer of the timing, the chronology of when the offers of judgment were with regards to that position. So you say that the offers of judgment were after it was determined in voir dire that they were conceding liability, or are you saying at the initial time? Would you mind clarifying? I was trying to parallel the chronology here for Real Water's position at the time of the different offers of judgment. I understand what you all ultimately did. I was here, right? But are you saying at the time that the offers of judgment were made that there was conceding liability at that time? Is that part of your argument, or you just, I wasn't really clear.
Is the court asking at the time the offers were made, had Real Water already conceded liability?
Yes, that's what I'm asking.
No, Your Honor. I believe it was a couple months later. The The earliest in time of these offers was in August 2023. And the last offer of judgment that was served in this case was in November. And I believe Real Water had conceded liability in the Gallagher case in October 23.
But sorry, I'm focusing in on this case, right? And I'm focusing in on, you all can correct me if I'm wrong, but I don't think I am. Mr. Odou had made a comment at a particular hearing that we're going to concede or thought they were going to concede liability. I don't want to put words in your mouth, but indicated a concession of liability at a hearing similar to what they've done in Gallagher. I think your phrasing was something like, yes, I presume we're going to concede liability just like we did in Gallagher. Later on, different counsel, different law firm came at a subsequent hearing, and this court's recollection was that counsel said that's still being determined, or we haven't conceded liability, or words to those effects. Then ultimately, liability and causation were conceded. So what I was trying to ask you is, at the time, if you're contending the status of liability is a factor this court should be considering, right, for the reasonableness of the rejection, how does that play into the timing of conceding liability? Because isn't that part of what you evaluate when you're looking at reasonableness? It seems to me your arguing part is that what actually went to trial should be evaluated for the court's reasonableness. And honestly, it's not a big point. You can move on. Go ahead if you want to.
Yeah, Your Honor, we were just making the point that our positions at trial were argued in good faith.
Okay,
And so,
but but is that the time frame that you're saying this court should be looking at when evaluating the rejection of the offer of judgment?
I
Do I look at the
believe,
trial time, or do I look at the time in which the offer was rejected?
that would go to different BD factors, Your Honor. I am speaking to Real Water's defenses were brought in good faith. And that timeline specifically would go to whether Real Water's rejection of the offers was grossly unreasonable.
Okay, thanks so much. I just thanks for that clarification. I wasn't sure which one you were trying to address that.
Understood, Your
That's
Honor.
why I was just trying to get
Understood.
that.
I'll try to be more clear.
No, no worries. I may have misheard it. No worries. Go ahead, please.
And so Real Water had admitted liability before trial, but what it did bring to the jury, what it did challenge, what it did argue was general damages, which is largely a subjective analysis and really left to the fact finder. And Real Water also challenged punitive damages at trial, which are damages that need to be proven at a higher standard and plaintiffs never have a right to them. So Real Water did proceed to trial on issues that it thought was fair game in good faith. Next, I'd like to turn briefly to the reasonableness of plaintiffs' ask for $53 million in attorney's fees. And I think that as the court cited to the opposition, if you just do some simple math, that is a shocking amount of money. And to put that into context, that amount of money under Rule 68 is for post-offer work. And so if we do a little bit of mental math here, if the offers were served between August and November 2023, and trial wrapped up here in early February 2024, that's about 5 to 7 months worth of work, $53 million. That roughly equates to $10 million a month in just fees. That amount is shocking to the conscious. Going into the Brunzell factors, as we did in our opposition, there was a lot of discovery in this case, but it wasn't a very complex issue. It was a strict products liability case. The plaintiffs were injured by Real Water. And the last Brunzell factor I'd like to discuss, which I think is interesting, is the actual results that the attorneys get for the client. And based on the situation in this case, those results have yet to be realized. Yes, there is a judgment, but based on the limited stipulation that lifted the stay, plaintiffs can only go after Real Water's limited insurance proceeds. So while they have a judgment, right now it's just a piece of paper, and they need to go down to Real Water's insurers and see what amount of money they can actually collect. Next, I'd like to briefly just touch on, in the opposition, we did say we believe that under the BD and Brunzell factors, plaintiffs are not entitled to any attorney's fees. But if the court is inclined to award some fees, we believe that the fees should be substantially reduced based on BD. And Real Water offered two starting points for that. First, the punitive damages award should not be used to calculate the contingency fee. Punitive damages are a special type of damage under the law and are designed to punish and deter rather than compensate plaintiffs or their counsel. And it would also be appropriate to take the punitive damages verdict out of the contingency fee calculation because Real Water defended against punitive damages in good faith. The second starting point for the court would be to hold plaintiffs at their the language in their contingency fee contract that I believe they represented in Mr. Pepperman's declaration, that the contingency fee is calculated based on the gross recovery, not what the judgment says. And so in this case, that is yet to be determined what gross recovery there is, if any. So plaintiff should be held to that in the alternative.
Okay, can I ask you a question on that one?
Yes, Your Honor.
Does that mean if somebody's judgment proof, nobody ever gets attorney's fees? If they go after somebody who's judgment proof? Because the recovery would be zero? I'm walking through your statement, right?
Yeah.
If you're interpreting gross recovery, which I think they've told a little bit different in their pleadings, they have a little different viewpoint. But if the court were to adopt, right, gross recovery, your view of it, right, what you actually can collect, then anytime somebody files a bankruptcy or is judgment proof, doesn't, from a policy standpoint, that means that the attorney gets zero. And how would a court be able to make a determination on fees now if I had to wait to see what they could actually recover? Would I be waiting 5 years, 10 years? You know what I mean? How long does a court wait? I read that argument and those were the two questions that kind of came to mind.
Yeah, I would say certainly in that different context with a judgment proof defendant, the plaintiff could certainly seek other avenues to calculate their attorney's fees. I think that in this context, plaintiffs are trying to use the Capriati case in an unprecedented way to collect $53 million in attorney's fees. And I think that if they want to go down that road, it's only fair for the court to hold them to the language that they're seeking to make Real Water pay for.
I'm gonna ask you to kind of finish up just because 12.
Yeah, absolutely.
My poor team right's been, remember, they've been going nonstop since before 8:30. I'm gonna give you a chance and give you counsel a chance to respond. But need to get them to lunch.
My last point, Your Honor, has to do with plaintiffs ask for their expert Greg Dooley and Mark Rich's expert costs, specifically in their motion for attorney's fees and costs. I'd like to point out that neither one of these gentlemen testified at trial. And Mark Rich specifically was a punitive damage expert that was offering opinions about the parties that have settled and no opinions relevant to real water in his report. And for Mr. Greg Dooley, he was a toxicologist and his opinions were irrelevant because real water had conceded liability. And unless the court has any more questions, I believe I'm finished.
I do not. Thank you so very much.
Thank you.
Appreciate it. Counsel for,
Your Honor, let's hit the last two. Mark Rich, as the court prior recalls, this was a heated discussion we had at the bench. Maybe even taking some time off and let the jury out so we could argue about it. We wanted to argue the industry. Mark Rich was going to provide testimony regarding the industry and deterrence and how much money you needed to deter that size of industry. The court said we didn't really want to get too deep into the industry, so as a result, we didn't call Mr. Rich. In terms of Mr. Dooley, Your Honor, you probably remember this as well, and you alluded to this earlier. I don't think Mr. Smith gave a direct answer to it. I'm not being critical of him because he wasn't there at the trial. But if you recall, the one plaintiff that the other firm was representing Real Water in regards to was Miriam Brody. And that's the person they said they weren't going to accept my causation or concede to causation with her.
Right.
And if you also remember, because the court—
she had comorbidities. Go ahead.
Exactly. And the court also remembers, the court got on both sides of this.
I didn't get on. I
don't know how many times, when are we gonna get the stipulation on a concession of liability? That, we didn't get that thing signed until we were almost done with trial. Your Honor, again, Mr. Smith wasn't here for all of that, but your recollection is very keen, Your Honor. We did not get a concession on defect and the liability until we were in trial. And you were on us every day to get that document in front of you because you were trying to determine how it was going to play into Terrible's position and what they would be allowed to argue. That was discussed too many times to remember, Your Honor. Now, what I also want to address is what Mr. Smith said. This was a simple case, Your Honor. It was a simple case. It was a case that was so simple that Real Water, after 3 years, couldn't figure out what was causing it. It was so simple that we had to bring the #1 hydrazine expert in the world who had written a couple of papers to come in.
Let's be, somebody wasn't here through the whole trial.
That's why I said,
Start to
I'm not
finish.
blaming Mr. Smith on this. He wasn't here. He didn't.
He did a nice job arguing their position. Go ahead, please.
He did. He did a wonderful job. And I would not want anyone, including Mr. Smith, to have to read through all the transcripts to remember all of this or to learn all of this. So this is not a Mr. Smith issue by no means. But this was not a simple case. We didn't bring the best hydrazine expert in the world here because it was a simple case. It was a simple case long before 2021, before the FDA, the CDC, and Southern Nevada Health District ran every test they could find to determine hydrazine. The product wouldn't have been on the market for as many years as it was. It wasn't a simple case. It took a lot for us to figure it out. It took a lot for the CDC, SNHD, and the FDA to figure it out. And then we had other tests to determine the hydrazine. So it wasn't simple. It wasn't simple from a litigation standpoint. And so, Your Honor, I beg to differ that this was a simple case. It was a complex case, which is, of course, one of the Beatty factors that has to be considered. The other point that I thought Your Honor made, and you were trying to get some clarification from Mr. Smith on this, the timing issue, Your Honor, also one of the Beatty factors, this is Beatty factor number 2, was the offer of judgment reasonable both in time, in terms of being in good faith, and in the amount. The timing, as we've discussed, Your Honor, were before we had a concession as to the defect and to causation. We were in the thralls of the battle. We were deep into it. We were preparing, getting ready to prepare and file all of the pretrial motions that we eventually filed. We were still taking depositions. We had learned a lot from the prior case, but every case, like you've said before, turns on the plaintiffs before this court. And so Dr. Hudson had to do a separate report involving each of these plaintiffs, their consumption of real water, and how that led to their acute liver failure. Your Honor, we meet all the Beatty factors. We meet the Brunzell factors. The other thing I want to point out, Your Honor, I just did some math because it's not in the briefs, the actual calculations, but our total offers of judgment for $2.8 million. Real Water in their closing suggested to the jury $13.858 million. They could have done a confession of judgment long before trial started for that amount if that's what they wanted to do. But they chose to fight us every, tooth and nail every step of the way. And the jury ultimately gave us $1.9 million, plus a little bit. When you can compare those numbers to Capriotti, 129 million. Did I say that? Yeah.
There's the word after that.
Okay.
Sorry.
Yeah, I'm sorry. The jury gave us 129 million. I saw complete confusion over there. When I looked over.
My wonderful team, you kind of blended another word right after you said 29 million.
129 million was what the jury gave us. If you compare that to Capriotti, that decision, the numbers certainly vote in favor of the request that we're making. The other factors that were listed by Smith are not factors recognized by the Supreme Court, Your Honor. This bankruptcy suggestion, if you're destitute, that means you can't get a judgment against you that for whatever amount, that there's no rule that says that. There's no case law that says that. Unless the court has any questions, I think we've briefed this pretty well. I don't believe that the defense
did, but I need to.
Persuasive.
The interpretation of the agreement with clients, which is two separate sets of interpretations, right? Because you represented one before you became co-counsel of everybody as well. Is it recovery based and recovery to be in term which you ultimately recover, or is it judgment based, since it was presented that the court should be looking at one versus the other? Can you just clarify that point?
Sure, Your Honor. I believe it's judgment based, and we have a judgment. We don't know what the Supreme Court will do. Although we have we can anticipate based upon the prior decisions. But every case that I've looked at and the cases that we've identified, they're based on the judgment, what we've been able to do in front of this jury. And ultimately, whatever the Supreme Court does, it does. But your decision will come before the Supreme Court decision. So every decision where the Supreme Court is affirmed, like in Capriotti, it was based upon what the jury awarded or what the fact finder awarded the plaintiff. And so I don't think the court should depart from the what I consider to be the instructions of the Supreme Court, given the cases we've cited, John.
The last one was articulated that the court should not take into account punitive damages for your contingency fee award. Did you?
That's a part of the judgment, Your Honor. Again, I've never seen that as a way of determining what the attorney's fee award should be under NRCP 68 or NRS 17.117. And I will say, Your Honor, I didn't see any case law from the defense that supported that argument either.
Okay. Here's the court's review. Appreciate the excellent briefing. Appreciate the excellent oral argument on behalf of everyone. Thank you. And yes, I'm going to try to make. Sorry, no need to get you guys out. Okay. Well, you all agree that the standards the court needs to look at, right? NRS 68 and NRS 17. You all agree that the court needs to look at the applicable case law, including Beatty and Brunzell. But also, of course, needs to take into the more recent case of Capriotti Construction versus Yahavi, 137 Nevada 675 from 2021. When I do all of that, realistically, I can walk through each and every one of the Beatty factors. But first off, you all agree, Schutte, even going back to Beezer versus Schutte, says that you can have a variety of different types of fees. Capriotti makes it clear the timing of when you do contingency fees, but you could have done contingency fees before then. Like I said, Beezer versus Schutte. So realistically, the fact that it's contingency versus, and there's other case law as well, right? Versus hourly, contingency is perfectly fine. The court has to grant it. The court is going to find that they have met their offer of judgment standards. So in determining any offer pursuant to 68 is governed by the court's discretion, right? Under Beatty, the court looks to whether plaintiff's claim was brought in good faith. Here, plaintiff's claim was brought in good faith. Obviously, there's admission of liability. That's kind of a foregone conclusion here. Admission of liability and causation. Whether the plaintiff's offer of judgment was reasonable and good faith, both to its timing and amount. Yes, it was. You have to look at the actual timing and amount and what was the situation that was at the time of the offer of judgment, and obviously the 2019. This is the post 2019 changes to the NRCP that the court has to look at. And I'm going to say see NRS 17 as well, because I'm really going to walk through Beatty walks through the NRCP 68. So that has been met, the amount combined 2.8-ish million. And you have to look at the timing of it. What was going on? What was the status with regards to liability? What was the status of the number of plaintiffs they had and the different actual alleged injuries of each of those plaintiffs? You have to look at, you can't look at just the grouping because this is a multiple plaintiffs. Everybody who had from a liver surgery to somebody who had a lot of comorbidities and was at a different sunsetting stage, I believe you said, of her life was used somewhere in the trial. If it was in the sunset of her life. You had a variety of ages, variety of different complaints, variety of different issues, variety of different times. When you look at all of those, each of the offers of judgment were reasonable. And when I'm saying this, I'm saying they're each. So each of the claims were brought in good faith. Each of the offers of judgment were reasonable, good faith, timing and amount. I'm going to adopt the arguments set forth in plaintiff's briefs just to be more succinct. Whether the defendant's decision to reject the offer and proceed to trial was grossly unreasonable or in bad faith. Court does find that it was, because realistically, at this juncture, the defendants knew that there was an issue of there being a chemical in water. What would be the result of what a jury would come back with? Maybe someone will question. The court cannot use a bankruptcy proceeding to say that somehow the decision to reject an offer is somehow going to be viewed in good faith, because if you think about that, like I said, that means anybody files a bankruptcy. You can file a bankruptcy one day, guess what? Reject the offer, then guess what? Take away the bankruptcy, depending on the nature of what bankruptcy you filed, right? Shortly thereafter, try to withdraw the bankruptcy. That can't be the law. Plus, you can't utilize the fact that you're in bankruptcy to say that you might not have the funds to pay it, to say somehow that means it's in good faith. Also, the court can't utilize the fact that there was limited insurance to somehow say that that made it was in good faith. It has to look at to whether or not for the claims at issue was the decision to reject the offer and proceed to trial grossly unreasonable and bad faith. The court does find that it was, because knew the result that there was going to be a finding of liability even before realistically it was conceded, and there was going to be causation because you had all that information. I have to look at the time, right? These were in 2023, folks. The timing of where that was, where the case was, for all the information that was available. And realistically, it was really a matter of what was going to be the number, not necessarily whether there was going to be liability with small little carve out with Brody, but then that was conceded as well. So do you find that it's unreasonable and bad faith, adopting once again the case law and the arguments in the plaintiff's briefs. So 4, whether the fees sought the offer are reasonable and justified in amount. That then ties into Brunzell analysis. Now here you have to tie into Brunzell, you have to tie into Capriati and a variety of different case law. And here where the court has to look at is, do I look at the number 53 million or do I look at the case law? I really have to look at the case law, my job. There's been cases, there's, Alvarez or was it Gunderson? Anyway, there's,
I said, you remember Gunderson?
yeah, where the Supreme Court, and I may be citing the wrong, anyway, the concept's correct, even if I don't have the exact case, where there's been more than one case where there's been significantly higher fee awards than there was for the actual damages awarded. Okay, it was Gunderson. I was like, I'm pretty sure. Okay, good. That's correctly. Even you can take those in defamation cases, right? The more recent Wynn case and stuff where it got $1. Okay, well, if you did it then that means the Supreme Court's affirmed. You know, I mean, when you've got small amounts in awards, high level of attorney's fees. So the court can't just look at the fact that it's $53 million. In fact, there's been legislative changes with regards to caps for certain types of fees, but that's the legislature, that's not the courts. So I have to look, the fact is a 40% contingency fee appropriate? Yes, it is, because the nature of this complex litigation, the nature of the fact of the type of issues involved, et cetera, the 40% is going to be appropriate. And I have to look at now, walk through the And plus 2 citations to multiple cases where 40% has been approved, 40% has been consistent. In the 8th Judicial District, there's been more than enough cases that have been 40% in looking at the actual contingency amount. The absence of any case law to say that the court should not be considering the punitive damages amount means that I have to also include the punitive damages amount. And also, it was a burden on the movement to show that punitive damages have, and other cases have, because of the plain language of the statute, says the penalty is for all the damages. It doesn't say carve out, right? There's that lovely Latin phrase, right? The inclusion and exclusion. If you want me to do the citation here that I can, I got it maybe somewhere, but anyway. Both the legislature and the statutory provision, the NRS 17, as well as an NRCP 68, does not exclude punitive damages. There's been numerous other awards where the punitive damages have been included with regard to the contingency fee. And so the court can't find that somehow this court should somehow preclude the punitive damages amount. So I now look at 40% and I look at punitive damages are included, and I really walk through now the Brunzell factors. It's not contested that the nature of the counsel, it's contested whether or not some of the counsel are fully developed in the case. But since I have a contingency factor here, the courts have not shown that just because certain attorneys might do more or less work, that somehow that means that I should change the contingency factor based on the difference of attorneys. So what do I look at? I look at all the factors I need to look at. The qualities of plaintiff's counsel establish the reasonableness of the requested contingency fee awards. That really wasn't disputed. A significantly experienced counsel who was the lead trial counsel. You set forth all your qualifications, see your pleadings, set forth the nature of these cases. Very successful. Those are all that factor is easily met. That would similarly go with Mr. Parker, Mr. Pepperman, and Ms. Switzler, all cited in here, all have done a significant amount of things. They played different roles. They played unique roles. Each of them handled different witnesses, did different aspects. I mean, obviously people are incredibly prepared for this case. So on both sides. So B, the character of the work performed establishes the reasonableness. Yes, the character of the work. Hundreds of demos. I mean, remember, I was here going through all of those with you, all the different pleadings that you all filed, all the pretrial motions, all the summary judgments, all the fact that we did unique aspects with jury questionnaires and how we addressed there, how the extensive voir dire, the various aspects of the nature of this type of case to try and explain a clear unknown substance that you can't really point to and kind of explain a difficult concept. B is easily met. C, the work actually performed establishes the reasonableness. It was a very complex case. It involved multiple parties with multiple injuries, which not only had the medical cause it with causation granted, even the damages component, and to explain the whole concept of Henderson, to explain what happened with regards to how it was made, how this uniquely was done, what is it, how it gets into water, how it gets broken down, where things were, how each of the plaintiffs would have got it, what were the impacts. So the work actually performed does establish the reasonableness. D, the results obtained establish the reasonableness. Here, the court has to take the results as it's had its plain meaning in all the other cases, which is what actually happened at the end of the trial. Here it's a jury awarded, in other cases it's been a bench trial award. That's the results. The court can't find, nor do the very authors of those agreements say that it should be viewed differently. So the court takes the results you've got 130 some odd $1 million. So obviously that ratio results to the actual offers of judgment. Even doing an individual comparison, by the way, the court looked at an individual comparison of each of the plaintiffs, because these are separate offer judgments. I'm not bundling them all together. In general concept, when you look at the compensatory awards, even absent the punitive damages, there's significantly high, but obviously adding the punitive damages, those ones do need to be divided out. But even compensatory damages, plaintiff by plaintiff, the result was very, very high. I mean, Brody got 1.6.28. Okay. That was the damages with the prejudgment interest. I was basing that on page 5 of your pleading. So I guess it was like 1.3 if I go back to the other one, but realistically, whichever number the court uses. So when you compare that to the offer of judgment, sorry, 1.295817 without the interest for Brody. And then Myles Hunwardsen got $23 million. Jasmine Schaefer, and these are public numbers, so I can say these ones, right? 2.1 million. Hortson, 2.2 million. Sosa, 2.08. So when you look at each of those numbers, obviously the results obtained. Yes. On several of them, you could take the combined offers of judgment were exceeded by at least, well, by Hunwardsen's award. The combined offers were pretty close to the award for compensatory damages with interest on at least a couple of them, and even without the interest, if you take it on the straight offers, there's still got over $2 million, which was almost as much as the combined offers of judgment, including Hunwardsen, which shows the results. So D, the results obtained establish the reasonableness of the contingency fee award. Court is going to refer, like I said, to Capriotti, Beatty, Brunzel, O'Connell versus Wynn, et cetera, all addressed in the pleadings and finding that it would both be proper. Do you all want me to walk through the NRS 17 factors? I went through 68, but as you know, NRS basically relies on 68. If you want me to go through the analysis as well, I mean, we basically say, see the pleadings, because 17 is fully addressed by the parties. But if you want me to read what the pleadings say, I can read what the pleadings say.
Not from a plaintiff's perspective, Your Honor.
Councilman Pence?
It's in the briefs.
It's in the brief, Sean.
Okay, so it's fine if I'm adopting the analysis, the same analysis would be with NRS, adopting the briefs would similarly find the reasonableness. The court's addressed the bankruptcy issue, I addressed the other issue, taking care of interest. So that does that. With regards to the two experts, I'm putting that on my to-do list since I said I was going to be addressing all the experts. And so I'm going to add those experts, regardless if I look at them as a 68 issue, if I look at them an NRS issue, I have to analyze them anyway. Any reason not to just analyze those last two experts with the other ones that I have to go back and double check on?
That's fine, Your Honor.
Does that work for you?
Yes, Sean.
Anyone need to be heard any further?
Your Honor, I just want to make sure that in terms of the attorney's fees number, that number would be 53,379,153.19. Is that the number you get?
That's the math that you all told me.
I believe so, and I think it's also reflected in defendant's brief as well, Your Honor. I just wanted to make sure.
Yes. Also, I mean, I'm looking at the numbers with the math. That's what. Councilor Defense, do you have a different mathematical number?
That was the number we cited. I presume the plaintiffs have checked it. and
Let me
that's
make
what
sure.
they're asking for.
Your Honor, let me do one more count just to make sure.
I was doing.
So it was I made one mistake. It's actually $53,379,153.90 is what the plaintiff says. And I took what the defense said at 19 cents. So that may be, we have 90 cents.
I think we just spent 90 cents arguing over it.
Okay. You wish the court to evaluate the difference between the 19 cents and the 90 cents, or can the parties agree to one of those numbers?
The 90, Mr. Odou?
Yeah, that's fine.
Not taking the discount to the 19?
No, I want Mr. Parker to get his 90 cents.
Thank you.
Okay.
I appreciate that.
Basically, it's doing the math by looking at page 13, right? A plaintiff's motion, the box has the 13,379, 153.90. And then the punitive damages, 40 million. You add those two numbers up, get you to the 90. If you needed the court to re-add up this cents, interesting. Since you all are agreeing on 90 cents, I'm not going to go back and add those numbers up, even though you might want to look at that last column and see what 4 plus 6 plus 0 plus 1 plus 6 equals. But
We'll take a look at it to make sure, Your Honor, but
anyway,
thank you, Your Honor.
but since you all agreed to 90 cents, I'm not going up. Okay. So I think I've now ruled on everything. Is there anything else the parties need the court to do other than you're going to thank my wonderful team who's probably starving by now?
Thank you, wonderful queen.
Sorry to start.
Thank
Thank you to the court and to the team.
Thanks. Thank you, Your Honor.
Okay, thank you. Okay,
Thank you.
so you're gonna get me orders, the fees order, okay. Now, here's my question, I do have to. Since remember, NRCP 68 and 17 goes to both fees and costs. Are you going to ask me to defer the order on fees and costs under 68 and 17? Because the court still needs to look at the experts' issues that's raised both in the motion for fees and costs under the offer of judgment rule, but it's also noted in the memorandum of costs and objected to in the motion to retax costs? Or do you want one order on fees to get that moving forward, and the cost order, since you're going to evaluate and talk among yourselves, you want the cost order to be different, but realize you're gonna have to split it by saying that the same costs that are awarded under NRS 18 would be similarly awarded under 68 and 17. Nobody raised any argument that there wouldn't be similar costs, correct?
We're not raising that argument.
I didn't see that argument anywhere. So, short answer is, what do y'all want with orders? Instead of talking about it now, I'm gonna tell you, get me orders within 30 days. But if you all are going to have any issues, I only show that the court has to look at the experts. And I have to, then you're going to submit blanks with regards on the costs, with regards to the ones that were not agreed to on court. And the court is going to put in those numbers because you want me to do the rest of those on the briefs in addition to the experts to evaluate it. Right?
Yes, Your Honor.
Yes, Your Honor.
Okay, thank you so much.
Thank you, Your Honor.
Have a good one. Sorry, folks, I tried.